Welcome to Leveraging Inspiration, the Inspired Patent Podcast, where we help you understand and leverage your intellectual property. I'm your host, Wayne Carroll. I'm joined here with Scott Gibson. We're excited to bring you insights and stories from the success and failures of others and teach you how to win at the game of intellectual property. Specifically today, we are talking about trade secrets. We're going to talk about what things to do to avoid a lawsuit when hiring. Before we get started, I always have a disclaimer. The information I provide on this podcast is for educational and informational purposes only. We are not providing legal advice, and nothing in this podcast should be construed as creating an attorney-client relationship. Welcome, Scott.
Thank you, Wayne.
So I found some statistics. There's a lot of false statistics out there, but I actually found an SBA report. Going to the SBA, you get good statistics, and this is a couple years old, but litigation costs for small businesses, they call them firms, are between $3,000 and $150,000 per lawsuit. And in a sample of cases, contract litigation was the largest. And, they just sampled a number of cases from the database that the federal government has. The survival rate of a new employer, so someone who's hired for the first time, it's about 69% for the first 2 years. And then if there's litigation, if I understood this article correctly, that survival rate falls to 33% for the 2-year period. And small firms actually hire 43% of all the high-tech workers, scientists, engineers, computer programs, and others. So this does not just apply to large companies. 43% of all these high-tech workers are working in small businesses. So Scott, is there a risk of getting sued when you hire somebody?
There is. Has the potential employee brought stuff with him? What has he done? Is he sharing you trade secrets? Trade secret law makes liability a stick for misappropriation of a trade secret. Misappropriation includes using someone else's trade secret, particularly if you know that information is a trade secret. So if you are hiring the top guy at a competitor because you want to duplicate what the competitor is doing, you need to slow down a little bit and figure out how are we going to make sure that he's not just bringing over everything he was working on at the old place. What do you do to make sure that you are protected from his theft of the trade secrets?
And is this standard for misappropriation of trade secrets? Does it also kind of include the you should have known? Does that come up a lot? Well, I didn't know because I didn't ask.
Well, not asking is not going to get you there. If you work for an ABC cola company and the top guy from Coke says, "Hey, let me come over. I want your new job, and I know all kinds of really good." He doesn't even have to say I know all kinds of good things, but he says, "I've got great ideas on how you can change your business, and maybe you need to be careful." Where did he learn those really great ideas? You need to exercise caution. Let me just say it that way.
You have a pretty extensive list in one of your articles, and I'll provide a link in the show notes. The article is called Conducting a Trade Secret Audit. I didn't measure how much, but it seemed like half or even more was about hiring. What are some highlights on that?
You want to look for places where an employee interacts with your trade secrets. Or if you're hiring someone else's experienced employee, where did that employee interact with the employer's trade secrets? And then exercise caution appropriately in those areas.
All right. Can you give us an example of something that someone can do to reduce their risk when hiring?
Well, one thing is you need to ask specifically, what were your duties and responsibilities? Do you have any agreements with your current employer? Do you have an employee handbook that maybe makes some requirements of you? And then you need to review them and determine, is this someone who has promised that I'm not going to disclose information, that I'm not going to compete in certain arenas? Those restrictions may or may not be enforceable, but you need to know what they are before you get a nasty gram from the attorneys for the other guy, the former employer. You want to know and make reasonable business decisions based on good knowledge, information, and judgment.
Okay. So in that hiring process, you mentioned asking things. Sounds like you would want to document that you're actually asking these questions.
Absolutely. Yeah, you may even want to develop a checklist that you include in your in your employee folder, where you ask, do you have any restrictive covenants? Yes, no. And you go through the questioning and you write notes appropriate to whatever the answers are. So you can again document and make, you can show that if this employee was taking secrets, you were doing your part to make sure that would not happen.
Okay. Yeah. Yeah. I worked at an Intel plant, and one of the people that I worked with, he shared the story of he was working for a company. He gave his 2 weeks notice. That company said, well, who are you going to work for? And he said, I'm not at liberty to say at this time. So they called security and said, okay, gather your things. You're leaving now. Not scary or anything. Just, this is our procedure. We're not going to have you sit here for 2 weeks gathering information because we don't know if you're going to a competitor. So large corporations have some of those kind of procedures. Are those in place for small businesses, or does it make sense?
I think it does. You need to, again, on a case-by-case basis, it's not one size fits all. You need to evaluate what is your risk in the particular situation. But if the person that has complete access to your secret sauce gives you notice that she's leaving, you need to determine, are we concerned or not? Now, the truth is, if the person is dishonest, it's probably already been transferred over, and you've got a different cause of action awaiting. But your trade secrets are protected regardless of whether you have a written agreement with the employee or not.
Okay.
Having said that, having an agreement is an indicia that you took reasonable steps to maintain the secrecy of the information. As you go back to that definition we talked about, the third point being that a trade secret is one where you've taken reasonable efforts to maintain the secrecy of the information.
Yeah.
That's what an agreement.
And reasonable effort will be different for a hair growth formula than for a cure for 10 different types of cancers that works great, and they can sell this for a $5,000 a dose.
Well, and it depends on what the business is and where the business is in the development. So Microsoft was famously started in a garage with a handful of initial entrepreneurs. What would be reasonable for them in that situation? Yeah, probably if they had a desk drawer that locked would be adequate to protect their information. If that's what Microsoft was relying on today, they would be laughed out of the courthouse. They would not nearly have taken the steps needed to protect their intangible assets.
Yeah, there's a large company that I know of that they had a policy. They would check at the end of the day, or it might have been at the end of the week, if there were any filing cabinets unlocked. If they were unlocked, then they would take the information in that filing cabinet and determine whether or not they were destroying it. And people learn real quickly not to leave a filing cabinet unlocked, because then they got to go talk to somebody about where'd my files go. So yeah, so that was one good way of implementing. Can you share any stories without, of course, breaching confidentiality about hiring gone wrong with trade secrets?
Well, I just finished a case that was not a trade secret case, but it involved some elements there where my client was a contractor and had one of his salesmen spend the last 2 months. He was working for the company, writing business for a competitor. That case just settled favorably for my clients, I might add, and a large six-figure number coming my client's way, a six-figure number that starts with a crooked number. So, yeah, that can be damaging. You know, the new employer got pulled into that because they were helping the guy transfer the information over, and they get to have him as their employee now. When I think he's shown his stripes.
Yeah. The SBA report, it's long, but it definitely focuses on not just the dollar and cent cost, but also the time involved and the stress involved in dealing with trade secret litigation, or litigation in general. But this, is actually about litigation for small businesses and the impacts it has. We're actually out of time, and we'd love to hopefully have you back another time and we can hit some other topics. So thank you so much for joining us, Scott. And
Wayne, it's been nice to be here.
You're welcome. This is Wayne Carroll with Leveraging Inspiration. You've been listening to Leveraging Inspiration, the Inspired Patent Podcast. We are live on ibgr.network at 3 p.m. Eastern Time every Friday. You can also find us anywhere you find your favorite podcasts. Our show today is sponsored by Inspired Idea Solutions Law Firm, an IP boutique law firm where we put your strategy first, use a proven process for success, and guarantee zero hidden fees. You can find us on the web at z3ip.com. That is Z as in zebra, the number 3, and IP as in intellectual property.com.
All of those sectors that need a molecule.
Yeah, no, absolutely. I think clearly one of the things I love about having been